Okay, we end our substantive material with a discussion of two cases, primarily, in which the court found that a law was not applied in a neutral way, that it was not a generally applicable, right, even-handed neutral law, and that heightened strict scrutiny would have to apply. Those cases are Hobbie on page 1284 and on page 1300, Church of the Lukumi Bablu I versus Hialeah. Let's talk. Okay. Free exercise is the clause of the Constitution, right, that's in play when you see the government allegedly targeting people based on their religious practices or religious beliefs, right? One more time, for old time's sake, if you see the government promoting religion, that's probably an Establishment Clause question. Now, under the Free Exercise Clause, what we've discovered so far, and again, this is the rule as of now, is that a generally applicable law under the Constitution, again, under Congress's RFRA, right, Religious Freedom Restoration Act, and under state RFRAs, you could have a different test, but the constitutional test that you're responsible for knowing for this course, right, if a law is generally applicable, then that's the end of the free exercise claim, right? There has to be something about the law or the way it's being used, right, that would raise suspicions that it's actually targets, right, the law actually does target religion or is being used to target people, right, based on their religious beliefs and practices. The two ways we've talked about, right, that a law could, right, that a court might hold that a law is not generally applicable or is certainly not being applied in a way that's generally applicable, would be, first of all, if there's something, right, built into the law that gives government, right, people in the government the opportunity on an individual basis, a case-by-case basis, right, to make decisions about, and the case is mostly about who would qualify for something and who wouldn't, right, under a government program. If the law has that kind of mechanism built into it, right, where, well, we're going to have a little hearing and we're going to decide, right, who qualifies and who doesn't, and we're going to decide that on a person-by-person basis, if that's built into the law, think about that. That's not a generally applicable law. I keep using the example because it's I think easy to understand of a speed limit, right? You don't have, you know, the speed limit sign doesn't say 70 miles per hour, you know, if a government official of some, you know, in some agency somewhere says that you should drive 70 miles per hour, right, and decides that you should drive 70 miles per hour, but maybe somebody else can drive some other, right, speed, based on an individualized hearing, right, on what, who's a good driver, who's not a good driver, right. You see laws like that, that's not generally applicable. So again, a generally applicable law is a law that applies the same way to everyone all the time, right. There is no individualized decision making as to who has to comply or how much they have to comply, right. There are no exceptions in the law. So in Hobbie, right, this really illustrates the point. You want to watch out for laws that have the opportunity built into them for individualized decision making. I call this, to simplify, built-in hearings, right, where the opportunity to pick on people based on their religious beliefs is present. The court concluded that is what happened in this case, right. Somebody was terminated from her job because she wouldn't work on Saturdays. So, but what happens, right? So, the way unemployment, and this is our second unemployment case, right? The way unemployment benefits typically work is you get unemployment benefits if you get laid off. Or you don't get unemployment benefits if you get fired for cause, because the government doesn't want to encourage people to be actively trying to get fired, right, from their jobs so that they can collect unemployment benefits. But if your job goes away and you get laid off, or you get let go for some reason that is not, right, not your own fault, then you qualify for unemployment benefits. And what the state was saying here in the Hobbie case is you don't qualify, right? And this decision is being made on a case-by-case basis, right? The decision is made under this law. You don't qualify for unemployment benefits because your firing was your fault. because you wouldn't work on Saturdays, right? When you took a job that required you to work on Saturdays, but then your faith changed, right? Your religious beliefs changed, and you decided you couldn't work on Saturdays, so getting fired was your fault and you're not getting benefits. That's what sets this up. So, if this is a fact pattern, you got to start at the top. Is the government promoting religion here, or is the government targeting religion here, right? Targeting religious beliefs. The allegation here, I hope you're thinking this through, right? If this was an exam question, the allegation here is targeting of religion. Therefore, this is not an Establishment Clause case, it's a free exercise case, right? So then the next question, is the law generally applicable? You're looking for built-in hearings or exceptions. This law, right, provides for built-in individualized decision-making and hearings. Therefore, this is not a generally applicable law. Therefore, what level of scrutiny applies? Strict scrutiny, right? The court says that, and basically says here the state doesn't even pretend that it can, right, survive strict scrutiny. What are they going to say? Save some money? That's not a compelling interest, right? So as the court notes, the state doesn't even argue that they can survive strict scrutiny. They're arguing for a lower standard. They don't get it. Okay. So when you see targeting like this under a law that is not generally applicable, in this case it's the unemployment right law that provides for these hearings, the court will apply strict scrutiny, and as you see here, obviously, right, the state loses, the government loses. Okay, we end with the Hialeah case on page 1300, and we have to end, right, constitutional law, your study of constitutional law at WMU Cooley, with an opinion written by who else? Justice Kennedy, he who hates laws, right? So, here we have the Santeria religion, right? The practitioners of Santeria, as part of their faith and part of their religious practices and under their belief system, engage in animal sacrifices. And what we have here is a city where word got around, right, that this was going on. People got freaked out, and they passed an ordinance, right, saying that you cannot, you cannot kill animals, and chickens is the most common one, right? You're not allowed to kill chickens as part of a religious ritual or as a religious ceremony. Okay, so once again we start at the top, right? What is the allegation here? Is the allegation here the government promoting religion, right? Or is the allegation here government targeting religion, right? This has nothing to do with providing material aid to religion. This has nothing to do with a display on public property. This has nothing to do with something going on in public schools where the government's promoting religion. None of that, right? The argument here the claim here is that the government is targeting religion. Therefore, which clause are you under? That's right, free exercise. So what's the rule under the free exercise clause, right? The rule is you look for whether the law is generally applicable. Okay, is this law generally applicable? A law that says you're not allowed to kill chickens if you're doing it as part of, right, a religious ritual or ceremony. I hope you spotted this. Laws that are generally applicable are laws that apply to everybody the same way. They don't have exceptions, right, written into them. So, is this law generally applicable? The answer is no, it is not, right? Because what? You can kill chickens, right, in the city, as long as you're not doing it as part of a religious ceremony. So the law might as well say you can kill chickens unless it's part of a religious ritual. Now, that's not a generally applicable law because there's an exception in there. I call it the KFC exception, right? If you're Colonel Sanders, you can kill chickens, right? If you're Chick-fil-A, you have at the chickens, right? But if you're doing it as part of a religious ceremony, no killing chickens, right? So is that a generally applicable law? Kennedy says no, it is not. Therefore, the law is subject to strict scrutiny. Now, there's not a lot in your case book about this, but let's walk through this. If you're facing strict scrutiny, there are a couple of arguments that can be made, right? One, I suppose, would be that the law is designed to save animals, right? Save the chickens. Okay, so what would be the problem then? Even if the court were to decide saving chickens was a compelling interest, and maybe it is, the means would have to be narrowly tailored. So consider that for a second, right? this is a law under which it is perfectly legal to kill chickens, right? If you're KFC or Chick-fil-A or any other person who's not killing the chicken as part of a religious ritual. So I don't know about you, but if I'm a chicken, right, and I have my head, on the chopping block, my last thought, if I'm a chicken, isn't, well, as long as this isn't a part of a religious ceremony, I guess this is okay, right? The point being, of course, that under this law, it doesn't save chickens, right? Chickens can still be killed. So that's it. Next, you might argue that this is about sanitary conditions, right? A health measure, that you don't want chickens being killed in this way because of bacteria and foodborne illnesses and all that. That you don't want this to be the way that the animal. You want animals to be killed in more sanitary and regulated ways. Problem with that argument, if you look at the full opinion, is that the way animals are killed in the Santeria sacrifices, and by the way, these animals are eaten, chickens are eaten as well. The procedures, right, and protocols under the Santeria religion are actually more sanitary than you would find at a KFC, right, or a meat market of some kind, right, where animals are being slaughtered, or slaughterhouse. So that doesn't fly either, right? If you're saying that your interest is in health and safety, right, this law doesn't achieve that, right? So the means are not narrowly tailored because you're stopping people from killing animals, right, in ways that are sanitary. So that's going to be a wrap on free exercise, right? First, you figure out which clause you're under, establishment or free exercise. If you're under free exercise, look for whether the law is generally applicable. When is a law not generally applicable? Either when it has built-in hearings in it, right, individualized decision-making, right, as part of the process under the law, or when there are exceptions, right? In these cases, you can see it's pretty easy for the court to discern that there's some kind of targeting going on here. That triggers strict scrutiny, and as always, right, the chances of surviving strict scrutiny are pretty low. But we will discuss the possibility in the current events, right, that maybe a restriction on religious gatherings might pass strict scrutiny under some circumstances. But we'll save that for our live discussion. Be well, and we'll see you for a live session Friday morning.